This is the Congressional Globe. What we're going to do is go back to the Civil War. How many people here, and don't answer me because I don't have time to take answers, it's rhetorical. How many people here know what the object of the Civil War was, officially, from Washington's perspective? Well, if you want to know, you go right here. At the bottom of this page, July 26, 1861, you have the object of the war, it's a resolution put out by Mr. Johnson of Tennessee. That's Andrew Johnson, future President of the United States. And it says this. I'm going to put it to where we can actually read it. And I'm just going to read the bottom part because the first two paragraphs are just fluff. It says that this war is not prosecuted upon our part in any spirit of oppression, nor for any purpose of conquest or subjugation, nor for the purpose of overthrowing or interfering with the rights or established institutions of those states, but to defend and maintain the supremacy of the Constitution and all laws made in pursuance thereof, and to preserve the Union with all the dignity, equality, and rights of the several states unimpaired, that as soon as these objects are accomplished, the war ought to cease. Now let's just go over that. It says the object of the war is not for any purpose of oppression. It's not for any purpose of conquest or subjugation. It's not for the purpose of overthrowing or interfering with the rights of those states, or overthrowing or interfering with the established institutions of those states. What's the established institutions of those states? Slavery. The official object of the war from Washington's perspective is not to overthrow or interfere with the institution of slavery. Is that what they teach us in school? Is that what they're teaching our children? They leave this off and let children just learn by innuendo what they think the war was about. And it's not what it's actually about. But they do say that the war was to preserve the Union with all the dignity, equality, and rights of the several states unimpaired, that as soon as these objects are accomplished, the war ought to cease. Now you got to remember, they had to convince Ohio Farm Board, what are you willing to fight for? New York Farm Board, what are you willing to fight for? Are they going to want to go fight to remove states' rights of New York or Ohio? You know, we're going to go to fight, get rid of states' rights. We hate states' rights up here in Ohio and New York. They're fighting to preserve them. Let's do a little quick timeline. The timeline of the object of the war to Reconstruction. And we kind of go through the war here. And we've talked about the resolutions. April, May 1865, the Confederate Army surrenders to overwhelming opposition. December of 1865, the 11 previous Confederate states are considered back in the Union to the degree that they participate in the amending of the National Constitution abolishing slavery. The 13th Amendment was ratified December 6, 1865. North Carolina passed it or ratified it December 4th, 1865. Who is the only people that Congress is allowed to send proposed amendments to for them to vote on and ratify or not? States. Did Congress recognize North Carolina as a state on December 2nd, 1865? Yes, we're a state. We're back in the Union. Object of the war is being accomplished here, right? So North Carolina's back in the Union, and the war's over in April, May 65, basically. It was kind of fuzzy. Peace is declared by presidential proclamation on April 2nd, 1866. So now we have peace in 1866. The 14th Amendment, the one we're talking about, the 14th Amendment is proposed by the 39th Congress June 13th, 1866, and is rejected by all southern states except Tennessee. On March 2nd, 1867, the first Reconstruction Act is passed by Congress in times of peace over the President's veto, declaring that no legal governments exist in any of the former Confederate states. So what just happened here? War's over in 65. The states are considered back in the Union in 65. 66, peace is declared. And in 1867, the object of the war is changed. 2 years after the war is over and a year after peace is declared. Congress changed the object of the war. They said it's for conquest. After the war's over. Here's Andrew Johnson's vetoes. Now, we're taught that Andrew Johnson is the most vile, wicked, terrible president. He's the only president that ever went, he's the closest president to ever get impeached. We have another one recently who deserved it a whole lot more, in my opinion. And he vetoed the Reconstruction Acts. Who was driving the Reconstruction Acts? The radical Republicans in Congress. It was a Republican Party thing. Andrew Johnson, Abraham Lincoln's, now get this. Andrew Johnson was Abraham Lincoln's vice president. Abraham Lincoln was a Republican. Andrew Johnson was a Democrat. They ran on the same ticket. Rather interesting. Andrew Johnson vetoed all these. Congress, the radical Republicans, hated him. And what did he say in his vetoes? Another ground on which these Reconstruction Acts are attempted to be sustained is this, that these 10 states are conquered territory and that the constitutional relation in which they stood as states toward the federal government prior to the rebellion has given place to a new relation, that their territory is a conquered country and their citizens a conquered people, and that in this new relation Congress can govern them by military power. And he says this, a title of conquest stands on clear ground. It's a new title acquired by war. It applies only to territory. So who did the title of North Carolina transfer from and to in 1867, in times of peace? From the free people of North Carolina to the federal government.
Carpetbaggers.
The federal government. There's not a foot of the land in any one of these 10 states which the United States holds by conquest. We have not conquered these places, but have simply repossessed them. From first to last during the rebellion and since, the title of each of these states to the lands and public buildings owned by them has never been disturbed. Now, this is the Commander-in-Chief of the Armed Forces. He's only allowed to send the military out to do what Congress says he's allowed to do. If Congress says the war is not for any purpose of conquest, can he use the military to conquer? No. So he knows, no, we didn't conquer. The U.S. military didn't conquer these states. We didn't do it. Who did it? Congress did it. The 39th Congress did it. Conquered the states in times of peace. Was that wrong or what? That was wrong. Did this go to the Supreme Court? Yes. I'm not going to go over Mississippi versus Johnson, but you have Georgia v. Stanton, and the court ruled that just because an act of Congress would annul and totally abolish the existing state government of Georgia is not within the jurisdiction of the court. So just because does Congress have the authority to pass acts that annul and totally abolish existing state governments?
No.
They did it. Are we taught this?
No.
In times of peace. Because a lot of people say the Reconstruction Acts were the logical conclusion to the end of the war. Is this the logical conclusion to what the war was prosecuted for, the object of the war? The exact opposite. What Congress is doing right here is not only spitting on the Confederate soldiers, it's spitting on the Northern soldiers who fought for the original cause. It says, what you fought for,
null and void.
Null and void. We're going to use what you fought and died for our personal gain, Congress's personal gain. Then you have Ex parte Macardle. The court accepted jurisdiction under the Act of 1867, and the case was argued before the court. Before the court could render a judgment, Congress enacted a law that replaced the appellate jurisdiction of the court under the Act of 1867 and prohibited from proceeding on any appeals already before it. What does that mean? The McCardle case is the only case in the history of the Supreme Court where you had a case that was argued. Now, this was on the constitutionality of Reconstruction, the constitutionality of Congress having the power to annul states, conquer states, subjugate their people. And it was actually argued before the Supreme Court. But before the court could render a judgment, Congress stepped in, changed the law, took away the Supreme Court's jurisdiction on the case, and said you're not allowed to rule on any case that this case comes. This is the only case in the history of this country that this has ever happened to. Only case. You have Ex parte Young. The Supreme Court accepted jurisdiction under the Judiciary Act of 1789, and immediately the Senate introduced a bill. Now here you have Ex parte Yerger. The Supreme Court's accepting jurisdiction, so they're going to argue the constitutionality of Reconstruction again. And the Senate introduces a bill. This was never passed. I don't want you to think that this was passed and it's still on the books. It didn't. But they introduced a bill explicitly prohibiting the Supreme Court from considering any case which involved the validity of the Reconstruction Acts, followed by another, still more radical, prohibiting the judicial review of any act of Congress. Yerger, on being turned over to the civil authorities, withdrew his petition, and that legislation was never enacted. Does it sound like Congress really wants to make sure that we have Reconstruction?
They're bullish.
Yes.